Maryland has a moderately to heavily regulated tenant screening environment that has become more restrictive in recent years, driven by legislative activity at both the state level and in local jurisdictions, particularly Montgomery County and Prince George's County. The governing framework includes Maryland's landlord tenant statutes, found in the Maryland Code, Real Property Article, Title 8, along with FCRA and the Maryland Fair Housing Law. If you're screening tenants in Maryland, you need to understand both the statewide requirements and the significant local variations that apply in different parts of the state. Let's start with application fees. Maryland has a specific statutory provision governing screening fees. Under Real Property Section 8-213, landlords can charge an application fee, but the fee must be reasonable and must be used to cover the actual cost of the screening. Maryland law requires the landlord to return the application fee if the landlord fails to process the application, or if the landlord knows that no rental unit is available at the time the fee is collected. While Maryland doesn't specify an exact dollar cap the way New York does with its $20 limit, the requirement that fees be reasonable and limited to actual screening costs provides a functional cap. Most Maryland landlords charge between $25 and $50 per applicant. Charging significantly more than the actual cost of screening invites challenges, and Maryland's consumer protection framework provides tenants with remedies for excessive or unfair charges. Montgomery County, one of the most heavily regulated jurisdictions in Maryland, has additional requirements regarding application fees and screening disclosures. Landlords in Montgomery County should review the county's specific provisions to ensure compliance with both state and local requirements. Criminal history screening in Maryland has been significantly affected by recent legislative activity. Maryland does not yet have a comprehensive statewide ban-the-box housing law with the detailed procedural requirements found in places like Washington, D.C. or Minneapolis, but the state has enacted reforms that substantially affect how criminal records can be used. Maryland expanded its expungement provisions through comprehensive criminal justice reform legislation. Under the Maryland Criminal Procedure Article, more offenses are eligible for expungement, and certain records are subject to automatic shielding, meaning they are removed from public access after specified waiting periods without requiring a petition. Landlords cannot consider expunged or shielded records in screening decisions. Maryland also enacted legislation addressing the use of criminal records in housing. The state has moved toward requiring landlords to consider the relevance of criminal history to the tenancy rather than applying blanket rejection policies. While the specific procedural requirements vary by jurisdiction within the state, the overall direction is clear. Maryland is moving toward a more regulated criminal history screening environment. Montgomery County enacted a fair chance housing law that is among the most restrictive local criminal history screening ordinances in the country. Under the Montgomery County Ordinance, landlords cannot inquire about criminal history until after making a conditional offer of housing. The landlord must first evaluate the applicant based on all other criteria: income, credit, rental history, and can only access criminal records after the conditional offer. When Montgomery County landlords consider criminal history after a conditional offer, they must conduct an individualized assessment. The assessment must evaluate the nature and severity of the offense, the time elapsed since the conviction, evidence of rehabilitation, and the direct relationship between the criminal conduct and the tenancy. The landlord must provide the applicant with notice and an opportunity to respond before withdrawing a conditional offer based on criminal history. Montgomery County's ordinance includes penalties for non-compliance, including damages, fines, and attorney's fees. The Montgomery County Office of Human Rights investigates complaints and takes enforcement action. Prince George's County has also been active in tenant protection discussions, and additional local criminal history restrictions may apply or may be enacted. Landlords in Prince George's County should monitor local developments. Baltimore City has enacted various tenant protections, and the city's political environment supports additional screening restrictions. Landlords in Baltimore should stay current on local ordinances. Howard County, Anne Arundel County, and other Maryland jurisdictions have varying levels of local regulation. Landlords operating across multiple Maryland counties should verify the specific requirements in each jurisdiction. HUD's 2016 guidance on criminal history and disparate impact applies in Maryland. The state's diverse population, particularly in the Baltimore and Washington, D.C. suburbs, means that criminal history policies that disproportionately affect minority applicants face significant scrutiny. Maryland's enforcement environment is active, with both state and local fair housing agencies investigating complaints. Source of income protection in Maryland is well established at the state level. Under the Maryland Fair Housing Law, State Government Article Section 20-705, landlords cannot discriminate against applicants based on their source of income. This includes housing choice vouchers, Social Security, disability payments, veterans benefits, and other lawful sources of income. Maryland's source of income protection applies statewide, covering every county and municipality. Landlords cannot reject applicants solely because they receive housing vouchers. Landlords cannot advertise that they don't accept vouchers or government assistance. And landlords cannot set income requirements that effectively screen out voucher holders when the voucher plus the tenant's income would cover the rent. The Maryland Commission on Civil Rights investigates source of income discrimination complaints and has enforcement authority. Fair housing testing occurs in Maryland, particularly in the Baltimore metro and the D.C. suburbs, and landlords who discriminate against voucher holders face enforcement action. Montgomery County has its own local enforcement mechanism through the Office of Human Rights that supplements state-level enforcement. For credit reports, Maryland follows FCRA requirements for permissible purpose and written consent. The adverse action process follows both FCRA and any additional state or local notification requirements. Maryland does not impose dramatically different credit screening procedures from the federal baseline, but the general expectation of transparency and documentation is higher in Maryland than in many states. Maryland's fair housing protections under the Maryland Fair Housing Law are broader than the federal baseline. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, marital status, age, ancestry, and source of income. The breadth of these protections, particularly the inclusion of sexual orientation, gender identity, marital status, age, and source of income, creates a screening environment that requires careful attention. Montgomery County has enacted even broader local protections that add categories beyond state law. Landlords in Montgomery County operate under one of the most comprehensive fair housing frameworks in the country. The Maryland Commission on Civil Rights investigates fair housing complaints and has enforcement authority including ordering damages, injunctive relief, and civil penalties. Maryland also has a robust private cause of action. Tenants can sue landlords directly for fair housing violations. Maryland has specific requirements regarding lead paint that interact with the screening process. Under the Maryland Lead Paint Poisoning Prevention Act, landlords who own properties built before 1978 must register their properties and comply with specific lead paint risk reduction standards. While this doesn't directly restrict screening criteria, landlords must provide lead paint disclosures to prospective tenants, and the lead paint compliance requirements represent an additional regulatory layer that Maryland landlords must manage alongside screening. From a practical standpoint, Maryland's rental market is shaped by two dominant forces: proximity to Washington, D.C., and the Baltimore metro, creating one of the most economically diverse rental markets in the country within a relatively small geographic area. The D.C. suburbs, including Montgomery County, Prince George's County, and parts of Frederick County and Howard County, function as extensions of the Washington, D.C. rental market. Rents in these areas are among the highest in the state, driven by federal government employment, defense contractors, technology companies, healthcare, and the massive professional services sector that supports the federal government. The applicant pool includes federal employees, contractors, military personnel, diplomats, and professionals from virtually every industry. Montgomery County is the wealthiest county in Maryland and has the most regulated screening environment. The county's Fair Chance Housing Ordinance, source of income protections, and comprehensive fair housing framework create a screening process that requires meticulous compliance. Montgomery County landlords should treat the county's requirements as their baseline. Compliance with state law alone is insufficient. Prince George's County has a diverse and more affordable market than Montgomery County. The county has a predominantly African American population and a large immigrant community. Criminal history policies face particular scrutiny in Prince George's County, and landlords should ensure their criteria are documented and consistently applied. The Baltimore Metro, including Baltimore City, Baltimore County, Anne Arundel County, and Harford County, has a more affordable market driven by healthcare. Johns Hopkins University and Medical Center is the region's largest employer. Education, government, defense, including Aberdeen Proving Ground, and financial services. Baltimore City has experienced significant neighborhood-level variation. Revitalized areas like Canton, Fells Point, Federal Hill, and Harbor East command premium rents, while other neighborhoods face vacancy and population decline. Baltimore City's tenant advocacy community is active, and the city has enacted various tenant protections. Landlords in Baltimore should stay current on local requirements and expect community scrutiny of screening practices. Fort Meade, home to the National Security Agency and U.S. Cyber Command, is one of the largest military and intelligence installations on the East Coast. Fort Meade generates enormous rental demand in Anne Arundel County, Howard County, and the surrounding area. Military and civilian intelligence community employees represent a significant and well-compensated segment of the applicant pool. Landlords near Fort Meade should understand military income documentation, leave and earning statements and BAH rates, as well as verification procedures for federal civilian and contractor employees who may work in classified positions with limited employer disclosure. The Naval Academy in Annapolis, Aberdeen Proving Ground in Harford County, Andrews Air Force Base, now Joint Base Andrews, in Prince George's County, and Patuxent River Naval Air Station in St. Mary's County all generate military rental demand in their respective areas. BAH rates vary across Maryland's military installations and directly influence local rental pricing. Frederick has a growing market driven by Fort Detrick, a major Army medical research facility, biotech companies, and commuters to both Baltimore and D.C. Hagerstown and Western Maryland have more affordable markets with moderate demand. College Park, home to the University of Maryland, has a tight student market. Screening students with limited credit and rental history is routine, and a consistent cosigner policy is essential. Towson, home to Towson University, Salisbury, home to Salisbury University, and other college communities have similar dynamics. The Eastern Shore of Maryland, including communities in Talbot, Dorchester, Worcester, and Wicomico counties, has more affordable markets with moderate demand driven by agriculture, tourism, and healthcare. Ocean City has a seasonal tourism market with workforce housing demand during the summer. One critical best practice for Maryland landlords: determine immediately which county and municipality your property is in and understand the specific local requirements that apply. Maryland's regulatory landscape varies dramatically from jurisdiction to jurisdiction. Montgomery County's Fair Chance Housing Ordinance, for example, doesn't apply in Baltimore County. Build your screening process around the most restrictive rules applicable to each property's specific location. Another critical best practice: never state in any form that you don't accept vouchers or government assistance. Maryland's statewide source of income protection is actively enforced. Remove any language from listings, websites, or policies that suggests you don't participate in voucher programs. Train every person who handles inquiries or applications that source of income discrimination is illegal throughout Maryland. A third best practice: for Montgomery County landlords specifically, implement the two-stage screening process required by the Fair Chance Housing Ordinance. Evaluate all non-criminal criteria first, make a conditional offer, and only then run the criminal background check for conditionally approved applicants. Document your individualized assessment for every applicant whose criminal history you consider. The Montgomery County Office of Human Rights actively investigates complaints, and thorough documentation is your primary defense. Maryland requires landlords to return the security deposit within 45 days of the tenant vacating. The deposit is limited to 2 months' rent. The landlord must provide an itemized list of deductions. If the landlord fails to return the deposit within 45 days, the landlord may forfeit the right to retain any portion and may be liable for up to 3 times the amount wrongfully withheld, plus attorney's fees. Maryland's deposit requirements are strictly enforced, and the 2-month cap makes thorough screening essential for protecting your financial interests. For the complete guide to Maryland tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.